Welcome to Property Law 101. I'm Sara Bronin, and I created the series to help you understand the basics of property law. We talk about four fundamental questions in this series, and today we're talking about the fourth question, which is holding an interest in property and in a very common form of property, which you know as a lease. Today we're talking about what a lease is and how leases work. The vast majority of people watching this video probably already know the answer to these questions because they've entered into a lease before, either as a landlord or as a tenant. In other videos, we cover the freehold estates, all of which relate to land ownership. The lease is a non-freehold estate, which relates to something other than land ownership, really temporary possession of property. Leases are structured to allow a landlord who owns the property to give a tenant or tenants certain rights to occupy a particular piece of property. In most cases, landlords and tenants will not know each other personally. So the lease is a pretty important document because it sets out the various rights and responsibilities of each party. More important because they don't know each other. Like a freehold estate, a lease will specify the premises to be leased, name the holder of the interest, and we require acknowledgement and agreement by both parties. A lease will lay out the particular uses to which the premises may be put. The most common lease is the residential lease, but of course, many commercial properties like restaurants or offices or movie theaters involve leases too. In some commercial arrangements, a landlord will retain control of the property through what's called a ground lease, where a tenant builds and owns a structure for a long period of time and is said just to lease the land. There are also rural leases like agricultural or grazing or mining leases that allow people to extract certain resources from the property. Even the federal government leases property for those kinds of purposes. Beyond the use of property, additional lease terms vary greatly depending on the circumstances and on the needs of the parties. For example, a residential space might be leased in a way that limits the number of people who reside on the premises or visit the tenant. A residential lease might have provisions about noise or parking or use of common areas. A commercial lease might be set up to require that the tenant business provides the landlord with a percentage of proceeds of operating the business. In commercial leases, there is a lot of deference to the negotiated terms because it is assumed that commercial parties will have either sophistication or lawyers. The interesting thing about leases is that they have some elements of what we would call traditional property law and some elements of contract law. For centuries, leases were considered to be exclusively a property interest, one that grants possession to tenants, where tenants bear all the burdens and benefits of possession. They couldn't get out of their lease unless the landlord interfered with possession. But in the 1960s, we start to see the law treat these more like contracts. As the video on default rules describes, both legislatures and courts have started to put or read default rules into leases, much like we do in contract law. On balance, that shift has created much more protection for tenants. With that general introduction to leases, I will leave it there. I'd love to hear from you, whether on Twitter or through my website. You can sign up to my mailing list there, and I will see you next time.